Hello friends, welcome back to another important video. Now friends, this channel is not just about JIB, CIB, promotions or bank certifications. But time and again, I also try to come up with complex queries or problems of bankers and help them in their day-to-day issues. Now, this video also covers one such important query of a senior branch manager from a nationalized bank. This video is in fact episode 6 of Bankers Help series. You can watch all these previous 5 episodes from the links given in description of this video. All these episodes will help you in gaining practical insights in making you a better banker. So friends, recently I received this email from one of the senior branch manager working in a public sector bank. He sent me this query. For security reasons, I have hidden the personal details. And his query goes like this. Dear sir, I am absolutely depressed right now. Genuinely on edge after getting a stern call and a show cause notice from the zonal office. We had a substantial FD of Rs 8.3 lakhs mature for a deceased account holder. Following procedure, I disbursed the funds to the registered nominee Mr. R on March 15, 2025. The problem, that is the real issue, is that a person claiming to be the sole legal heir, Mr. K, had already submitted the death certificate and staked his claim back in December 20, 2024. That is months before the maturity. Now it's April 20th, 2025 and I am being grilled by our zonal office being asked why the payment went to the nominee and not the legal heir. I feel sick with worry and utterly confused. What did I miss? Where did I go wrong? And to make the matters worse, the nominee has already accessed a significant portion of the funds and I am just lost. Please sir, help me to counter this issue and frame a reply which I can send to the zonal office. So friends, this banker's worry is very real and common. It shows how tricky it can be to handle money after someone dies, especially when a nominee and a legal heir both shows up. I found this query important and thought of making a video that will help whole banking community. Friends, this query is not an isolated incident. It covers a fundamental challenge faced by bankers across India, which is reconciling the straightforward process of nominee payment with the complex and often emotionally charged claims of legal heirs. So let's dive into the scenario, dissecting the legal framework, procedural lapses, and best practices to transform this confusion into clarity for every banker. Now, to truly understand the core issue of the problem, we must first understand the distinct roles of a nominee and a legal heir under Indian law. This discussion is the basis upon which all decisions regarding deceased claims are based upon. First, let's see who a nominee is. Friends, please note a nominee for a bank account is a person or entity explicitly designated by the account holder to receive the proceeds of the account upon his demise. This nomination is in fact a facility provided by Banking Regulation Act 1949, specifically sections 45ZA, 45ZB and 45ZC with extensions for locker and articles. So legal status of a nominee is actually that of a trustee or custodian. Friends, this is the most crucial point which is often misunderstood. The nominee's legal status is that they act as a trustee and custodian of the funds only. They are the medium through whom the funds pass from the bank to the ultimate beneficiaries. They do not become the absolute owner of the funds. Their role is similar to that of the caretaker safeguarding the funds until the rightful legal heir claim them. So what's the bank's protection here? Friends, please note, if the account holder has appointed a valid nominee, then the bank is empowered and is in fact obligated to transfer the fixed deposit amount or any other deposit to the nominee without requiring a probate order, succession certificate, or even other cumbersome legal formalities. This provision in fact serves to protect the bank from litigation and provides a swift mechanism for families to access funds in the time of distress. So this payment to the nominee provides a valid discharge to the bank from its liabilities in respect of the deposit. I hope this very important point is clear to you. Next, what about the responsibility and distribution? Friends, the nominee is indeed responsible for safeguarding the funds until a legal heir claims them. They are in fact entitled to withdraw the fixed deposit amount after account holder's death. However, they do not have legal right over the deposit in terms of ownership. Their most important duty is to distribute the funds to the legal heirs as per inheritance laws applicable to the deceased. Next, let's talk about the legal heirs. Friends, a legal heir is an individual or individuals who by virtue of the personal laws, example Hindu Succession Act, Indian Succession Act or Muslim personal law, etc. are entitled to inherit the property, assets and liabilities of a deceased person. Then, unlike a nominee, a legal heir is the rightful and absolute owner of the deceased assets, including bank deposits. But please note, establishing legal heirship often requires formal documentation such as legal heir certificate, succession certificate, or a will that has been probated depending on the value and nature of the assets and state laws. Now friends, before moving ahead with the video, don't forget to get my latest book, The Fearless Banker, which is specially designed for all the bankers irrespective of your scale or cadre you are working in. Now this is a very special book. If you have ever faced a deceased account settlement, a nominee dispute, problematic bank guarantee, or a loan proposal that looks perfect on paper but smells wrong, then this book is your answer. Friends, The Fearless Banker is not just theory. It's 39 practical case studies with step-by-step solutions for the toughest branch situations. Whether it's customers' anger, locker complications, or legal notices. This book shows you exactly what to say, write, and do in tough situations at the bank. It's not a textbook, it's your branch side mentor. So don't wait for the next problematic situations, be ready. Link is there in description, order now and become the confident, fearless banker you were meant to be. So let's move forward with our video. Next, let's re-examine our banker specific situation and apply the principles we just learned. The first is initial correct action. Now friends, our banker's action of transferring the maturity amount to Mr. R, the registered nominee, on March 15, 2025 was in isolation perfectly aligned with bank's discharge of liability under the Banking Regulation Act. The law specifically states that payment to nominee provides a full discharge to banking company. Then next comes the crux of the matter. On December 28, 2024, a full 3 months before the FD maturity and subsequent payment to the nominee, Mr. K claimed to the legal heir and presented a death certificate. Friends, this single event dramatically altered the landscape and was in fact the core reason why Zonal office issued a show cause notice to senior manager. So as you can see, while the bank's legal liability might still be considered discharged by the payment to the nominee, but there is still the procedural lapse that lies in not pausing, that is stopping the process and addressing the legal heir's claim before disbursing funds to the nominee. Once the bank receives a claim from the legal heir, accompanied by supporting documentation, the funds are put on notice. This is no longer a straightforward nominee payment scenario, where no other claimant has to come forward. Friends, a prudence, good governance and a customer-centering approach dictate that at this juncture the bank should have first communicated, that is, immediately inform both the nominee, that is Mr. R, and claimant, that is Mr. K, about the conflicting claims. Then next, bank must encourage both parties to resolve the matter among themselves, possibly by obtaining a succession certificate or a court order that establishes the legal heir and directs the distribution of the funds. Next, the bank must temporarily hold the payment of the nominee until the conflict was resolved or until a reasonable period has passed without resolution, following which the bank could have then proceeded with the payment to the nominee while clearly informing him about his trustee obligations. Next comes another major issue, that is of the nominee withdrawing funds. Friends, the fact that Mr. R, the nominee, has withdrawn some of the funds does not invalidate the bank's initial payment from a legal discharge perspective. However, it shifts the battleground. Mr. R, as the trustee, is now directly accountable to the true legal heirs for the funds he received. He cannot claim ownership, and if he resists disbursing the funds, the legal heirs can pursue him legally but not the bank. As a banker, senior manager is completely safe. Now, how should senior manager address or reply to the bank management or zonal office confidently and professionally? So first, the manager should acknowledge and explain the legal foundation. And he should start by saying, "Sir or Madam, my actions on April 28, 2025 to pay Mr. R, the registered nominee, were in line with Section 45ZA of Banking Regulation Act 1949. This section explicitly states that such payments provide a valid discharge to the bank. The intent of the nomination facility is to simplify and expedite the release of the funds to the designated person, thereby protecting the bank from prolonged legal disputes and provide quick access to the funds for the family. Next, the banker must address the procedural lapses, if any. And he can continue by saying, "However, I acknowledge that the situation was complicated by the claim received from Mr. K identifying himself as a legal heir on December 20th, 2024, which was prior to the maturity and payment date. While the law protects the bank for payment to the nominee in retrospect and for enhanced customer service and risk management, we should have perhaps paused the payment process upon receiving the legal heir's claim. This would have allowed us to engage both parties and advise them to seek clarity on the rightful ownership, potentially through a succession certificate or mutual agreement." Next, the senior manager must clarify the nominee's post-payment responsibility also in his reply. And he can continue by saying, "It is crucial to understand that Mr. R as a nominee is merely a trustee. The funds he received are not his personal property. He is legally obligated to hold these funds for the benefit of the true legal heirs of the deceased account holder, as determined by the personal succession laws. The fact that Mr. R has withdrawn some of the amount does not change his trustee status. The legal heirs now have a direct claim against Mr. R to recover the funds, and the bank, having discharged its liability by paying the nominee, is generally not directly involved in that subsequent dispute, though we can certainly facilitate the communication." Lastly, the manager can close his reply with suggesting some forward-looking solutions. And first is intervention with nominee. And he can continue by saying, "We should immediately contact Mr. R and formally reiterate his legal position as a trustee. We must clearly inform him of his obligation to distribute the funds to the legal heirs and the potential legal ramifications if he fails to do so. This communication should be well documented." Then second is guidance for legal heir. And he can continue by saying, "Similarly, we should inform Mr. K that the bank has made payment to the nominee as per the law and that Mr. R is legally bound to transfer the funds to the rightful legal heirs. We can advise Mr. K on the steps he needs to take, such as approaching Mr. R directly or seeking legal recourse. Example, obtaining a succession certificate in case Mr. R is uncooperative." So friends, I hope this formal reply is clear to you. But many times zonal office or head office people are not in a mood to get teased or being tutored or hearing some suggestions from branch people. So a simple, straightforward but effective reply to this situation can be like this. "Dear Sir or Madam, the payment of Rs 8.3 lakhs on 15th March 2025 was made to the registered nominee Mr. R as per the valid nomination on the record, in line with Section 45ZA of the Banking Regulation Act 1949. As per established RBI and legal practice, the bank is discharged from liability once payment is made to the nominee. Mr. K's claim as legal heir was not supported by succession certificate or probate at that time. The payment to the nominee was done in good faith, and the nominee has already withdrawn partial amounts. Any claim by Mr. K can be pursued in a civil court against the nominee, not the bank." Now this last line is very important, and this saves the senior branch manager. Thank you, senior branch manager. Now friends, this is to the point reply without admitting that you have committed anything wrong, neither preaching zonal office what should have done or what the bank could have done better, like communicating with both the people, etc., etc. So you should analyze your top management people sitting above and reply them accordingly. So friends, out of all these, what are the key takeaways for the bankers? So this experience of the senior manager, while unsettling, offers some very important lessons that can enhance every banking professional's knowledge. And some of the takeaways from all the bankers are: first is nominee is trustee. Engrave this principle. Friends, this is the golden rule. Never confuse a nominee with a legal heir. The nominee is a facilitator, not an inheritor. Constantly reinforce this in training and customer interactions. Then second is due diligence is important, especially with conflicting claims. Friends, the moment a legal heir claims the benefit before payment to the nominee, the situation shifts from routine to requiring heightened security. A simple death certificate along with succession certificate or other court document presented by the legal heir is a signal to pause and assess. Then third takeaway is communication is your biggest tool. Friends, clear, documented communication with all involved parties, that is nominee, legal heir, and your own management is vital. Advise, inform, and guide. Transparency in this situation can prevent show cause notices and other actions by management against the bankers working in the branch. Then next is the banker is a facilitator, not a judge. Friends, your role is not to determine who the true legal heir is in a disputed succession. Your role is to stick to banking laws, facilitate processes and guide customers toward appropriate legal mechanism, like the succession certificate if the dispute arises. And last key takeaway is ethical banking. Friends, beyond legal compliance, ethical banking demands that we ensure funds reach their rightful owners. While the bank's direct liability might be discharged, but facilitating justice for the deceased family upholds the bank's reputation and earns a banker lasting trust. So friends, in this case, my reply to the senior manager was simple. Along with the formal reply as discussed above, I simply replied the senior manager as, "My dear friend, take a deep breath. You did not commit anything wrong in the sense of defrauding or violating a direct legal regulation. Your action of paying the nominee was covered by the discharge provisions of the law. However, the show cause notice is an opportunity to learn and improve. The oversight was a procedural one, that is, the failure to adequately pause and address the legal heir's prior claim. By acknowledging this, explaining the legal regulations in reply, and proposing concrete steps for the future, you will not only resolve this immediate crisis, but also contribute significantly to strengthening your bank's internal processes and the collective wisdom of your colleagues. This experience should serve as a powerful reminder for all the bankers that in banking, while rules provide the framework, proactive communication and a deep understanding of the spirit of the law are what truly build trust and ensure smooth operations when you face a complex situation. You must without any fear go forth, explain with clarity to your zonal office, and let this movement be a stepping stone to even greater mastery in your esteemed profession. Friends, I hope the problem discussed and the solution is clear to you. With this, I wind up this video. If you also have any queries, then you can mail me your queries to this email ID. And also don't forget to get your The Fearless Banker book. This will give you many more such cases and expand your banking horizon, which will help you in tackling many such complex scenarios in the bank. So thank you, and I will meet you again in another video.